Advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands. Welcome in, everybody, to Taking Care of Business today, featuring Rob Melick with Melick Law. Rob, good morning.
Good to see you again.
Good seeing you as well. Always love having you on, especially when the Brewers are doing so well.
Mm-hmm. Yep, 3 out of 4 in LA. Can't ask for much more.
You know, Wally Lukashinsky and I were having a great discussion the other day. Of course, Wally, one of the hosts of Dam Sports Show on 1430 ESPN Beaver Dam, and he was saying that the Brewers going to the West Coast is almost a guarantee for us just to walk away with a bunch of losses. It's got to feel pretty good that we're not necessarily sticking to that right now.
Well, and I think, from a philosophical standpoint, obviously if you had to choose between winning against the Padres versus winning against the Dodgers, you choose the Dodgers, right? Because they're the evil empire. They're the best team in baseball. So, a tough series against the Padres, but at least they took 3 out of 4 against the Dodgers. Can't ask for much more than that. So.
You really can't. How do you feel about the team right now, how it's shaping up?
I feel pretty good. Like I said, it's about doing it in the playoffs, though. We've been down this plan quite a few times before, but hopefully it changes this year in the playoffs. We'll see. Keep our fingers crossed, as always. So all we can do as Brewer fans. Keep the faith.
Now, of course, this time of year, we're talking baseball, but also we talk a little bit about football. Obviously, Packers have gotten one pregame under their belt, which it's the preseason, so say what you will. But you're thinking about it from a coaching standpoint.
Yeah, I'm the head coach for my son's 7th, 8th grade team out in Milwaukee, University of School Milwaukee. So he'll be an 8th grader this year, so this will be my last year as a head coach. So once he graduates and goes to high school, I'll have both boys in high school next year on the same team. And given their 3-year age gap, I've never had that before. So I'm going to enjoy every minute of having them on the same team next year. But for this year, we start on Monday with our practices. So we have a 6-game season, so it should be fun.
There you go. You find so many ways to keep busy, and we appreciate it. Your primary way of keeping busy, though, has nothing to do with baseball, necessarily. Nothing to do with coaching football, per se, but has everything to do with helping people with navigating what can be a very sensitive time in their lives.
Sure, and that's why it's called estate planning, and that's why I really emphasize the word planning portion of it, because I would argue with any decision we make in life, whether it's something as important as estate planning or as simple as preparing meals for the week, right? The more we plan, the easier it is.
Right.
It seems overwhelming when you have a long, tough day at work and you got to prepare a home-cooked meal. Well, if you do it before on a Sunday when you have more time and you set it up for the week, that can reduce some stress. It can make things go easier when you have the time to do it. When you're scrambling, that makes it difficult. Like I said, whether it's making sure you get gasoline in your car or create an estate plan, the more time we have, the better off we are. And that's what I try to emphasize with people on this radio show and just with people in general is the more time that you give yourself, the less burdened we are with it, and the more we can contemplate it. And more importantly, things can change, right? If you create an estate plan now, what's the likelihood it's going to be the same 20 years from now? I'd argue pretty low. Life circumstances change. I've shortened it down to what I call the 3 Ds and a B: death, divorce, disability, birth, right? These are 4 pretty common life events that frequently will cause people to want to update their documents, and you have the ability to do that. But along those lines, I also tell my clients an imperfect estate plan is better than no estate plan. A lot of times people take the time and, I don't know what's going to happen. Let me wait till I figure it all out. Well, that's great. But if something happens in the interim, we don't have a plan, the state of Wisconsin creates one for you. And most people don't like the plan the state of Wisconsin creates for you. They want to make sure that the money they've worked hard for during their life goes to the people and the causes they want it to go to with as minimal time, cost, aggravation, and governmental interference as possible. And that, in one sentence, is what I help people do. I help people, to use your word, navigate that process of getting from where they are today to the inevitable point of their deaths. Because let's face it, that is an inevitability. Every single one of us will pass away at some point. We don't know when, we don't know how, but it's going to happen at some point, which kind of makes this area of law relatively unique, right? I mean, if you have a criminal defense attorney, not everyone's going to get accused of a crime. If you're a personal injury attorney, not everyone's going to suffer an injury like that. Not everyone's going to get divorced, but there's a 100% chance we're all going to pass away at some point, and 100% of the population needs to make sure that we have a plan that adequately prepares for that and minimizes that cost and time during an emotionally difficult time for the people you leave behind. So that's what we help people do at Melick Law, and we've been doing it. September 1 will be my 10-year anniversary of opening up my own firm. So by the next time I come in and record a show here, it'll be 10 plus years as a sole practitioner and 19 years practicing overall.
That is absolutely awesome. And for people who want to get in touch with Melick Law, let's get that information out there right away. What are the best ways to get a hold of you?
Yeah, so the best way to get a hold of me is by phone. Like I said, I do have 4 offices. We'll talk about that in a second. But my number for all those offices is 262-347-3444. Again, 262-347-3444. For the majority of the listening and viewing audience, the Beaver Dam location will probably be the most convenient. I am blessed to have the opportunity to let the hires let me use their office in Beaver Dam, right in the old Heritage Hills Mall, between what used to be the Joanne Fabrics and what used to be the Slumberland Sears area there. I guess it's still Slumberland, but we're in that office. But I do also have office locations in Saukville, West Bend, and Germantown. Whether you hear about me from this show or in any other way, I always do offer free initial consultations. So, again, what I try to do is I try to remove any barrier, because I've learned in my 19 years of practice that people will come up with whatever excuse they need to come up with to not see an attorney. It's just the way it goes, right? So one of the issues is cost. Well, I remove that hurdle because I don't charge for initial consultations. Furthermore, if you are a WBEV listener or a DailyDodge.com viewer, I do offer a 20% discount off of legal services. So if you do decide to book an initial consultation, you decide to go forward, mention to me that you heard me on WBEV or saw me on DailyDodge.com, and we'll take 20% off the legal bill for you. In addition, I do make house calls. I do have clients who perhaps have mobility issues. Perhaps they have issues with child care. They don't want to get a babysitter to go meet the attorney. I do offer in-home calls as well as virtual calls. We can do the initial consultation via Zoom, via telephone, whatever mechanism it is. Again, my goal is to try to make that initial consultation occur, removing all impediments to having that occur, because what ends up happening in my experience is once people actually have the opportunity to sit down and understand firsthand what an estate plan can do for them, why they are better off with having an estate plan than not having an estate plan, usually people decide to go forward, because it really is that information gap. And I know that's why I do shows like this, right? To try to bridge that gap, but certainly in an in-person meeting it helps because you're hearing it one-on-one as opposed to through a broadcast. But again, what I always tell my clients is creating an estate plan costs significantly less than not creating one. Because if you don't create one, that's when the courts typically get involved. That's where you lose say over where the assets go. So take a couple minutes, sit down with an estate planning attorney, learn your options, and then come up with a plan that is tailored to those options and making sure that your preferences come to fruition.
Now, you mentioned being lucky enough to share an office over there at Hire Insurance, and recently, matter of fact, just on Friday, we had Matt Hire on, who, quite the reverse, said he's lucky to have you in the office. Mentioned that he knows just enough about what you do to be dangerous and probably say things wrong, and that's why he loves that he can lean on you, because obviously he's not a lawyer, he hasn't done the training, but to that extent, you are. And you could have gone into any aspect of law you wanted, and you opted to go into estate law.
I did, and I feel the same way about Matt. I'm lucky to have him and Sandy's resources as well, because, again, they know what they know, we know what we know. We work together as a team to help clients' objectives there. But, yeah, I mean, estate planning, it is kind of a relatively unique area of the law for many reasons. But again, and I went to, just for a little bit of background on me for people who don't know, I grew up here. I grew up in Washington County. Went to high school here, but I went to college and law school out in Pennsylvania. I was getting recruited to play football at a college out in Pennsylvania, did my undergrad there, and then graduated from Penn State Law School. And Penn State's law school, similar to their undergrad, is a pretty big law school, so 250 kids. And again, I'd be lying if I said I knew all 250 of my fellow graduates, but the ones I know, there's only 3 of us who practice estate planning, which is kind of surprising. And one got into it a lot later in her career. She was working at a corporate firm, decided that wasn't for her, and then opened up her own firm, focused on estate planning. So, like, among my really good core group of friends, I'm the only one who does what I do. And, you know, to me, I really got into it kind of by accident. I worked at a firm out of law school, basically the highest paying salary job I could get to help me pay down law school debt. I was a corporate lawyer. I represent a lot of contractors, subcontractors, things like that. But it's a very fast-paced, a lot of argumentative aspects, and just wasn't for me. So I ended up leaving that firm, and I went to a more general practice firm that did a bunch of things, litigation being among them. But I also started working with the estate planning attorney there. And one of the things he said to me that always stuck with me through my practice, he said, you know, you're a young attorney, consider estate planning, because unlike other areas of law, there's 2 things that make estate planning a better fit for a lot of people. One, there's no opposing counsel, right? It's not a zero-sum game, right? You know, if I go to court in a normal case, there's a winner, there's a loser. Now, sometimes it's split in the middle. You know, if I sue for 100,000 and the company doesn't want anything and they settle for 50, I mean, who's the winner there? It's kind of in the middle, right? But generally, that's how it works. With estate planning, it's not that way. And secondly, there's no court deadlines, generally speaking. I mean, there are court deadlines for probate, of course, but for the majority of my practice, when I meet with clients, I create estate plans, there's no deadline. That creates time crunches and urgency and things like that, or causes you to miss vacations or whatever the case is. So I've been very blessed to have had that opportunity in the practice of law and in doing what I do, but it is a very different type of law. You know, the example I give is this. I have a buddy of mine who was a criminal defense attorney in New York. He's since opened his own practice. He worked for the public defender's office and set up his own shop. And I remember chatting with him one time. I said, "You drop an alien on this planet, have him shadow you for a day, have him shadow me for a day, and there's no way they think we're both lawyers, right? We do very, very different things. This is a guy who goes to Rikers Island to meet with clients. I mean, very different than my day to day, right? So it is interesting. And that's what's nice about the area of law, or the practice of law, that you can go to law school. I had no idea I wanted to be a estate planning attorney going into law school. I didn't know when I graduated that I wanted to be an estate planning attorney. It just kind of fell into it, and I've been very fortunate to have had that encounter because I really love what I do for a living. So.
I have to admit, I've watched, and we've talked to us a little bit in the past. I've watched a lot of different shows that depict lawyers in a lot of different ways. And when I picture the lawyer standing in court, you know, yelling objection and getting heated with a witness, or I don't picture the laid back, helpful guy that is Rob Melick. I mean, maybe I could see you getting that heated at a Brewers game or a bad call, but never quite in this case. But that actually works to your benefit because, you know, a lot of times when people are having these discussions, it is relating around, again, very sensitive topic, the fact that, you know, mortality is 100%. Nobody's getting out of this alive.
Right.
And talking about that with somebody, you want somebody who's going to be, I guess I could say, level-headed and pragmatic about the conversation.
Yeah. Well, it's one of the things as a lawyer, we're encouraged to divorce ourselves of emotion. And that's exactly what I try to do. Because, I mean, of course, I'm a human being, right? I have many roles. I'm a father, I'm a son, I'm a husband, I'm a brother. But at the same time, as a lawyer, people come to me for legal advice. That's what they do, and that's what I provide them. I do it without emotion. To quote the famous line in A Few Good Men, when Kevin Bacon and Tom Cruise, who are both lawyers, said, "I represent my clients without passion or prejudice." And that's exactly right. I mean, that in one sentence kind of summarizes what I believe a lawyer should be when it comes to this area of work. Now, don't get me wrong. Like you said, you're in court, you get heated. A lot of that's theatrical and things like that. But a lot of people are that competitive, and that's just not me. So, again, I try to give my clients objective advice. And, again, in that regard, and I say this to my clients frequently, you are my boss, okay? I don't tell my clients what to do. I explain the pros and cons of either doing something or not doing something, and then it's your choice ultimately as to how you want to do it. My job is to make it legal. Now, if you want to do something that's illegal, then I can't help you with that. I mean, the example that I always use is this, and again, this is an absurd example. I've never had this come up in my practice, but let's just say someone said, you know, on the side, in addition to my job, I run a meth lab, and I want my meth lab to go to my children. Well, I can't do that. I can't contract for something that's illegal, right? But beyond that, it's my job to make sure that I understand what my clients want. After I've thoroughly explained to them, again, pros and cons, and then let them make an informed decision about how they want to proceed.
I want to touch on a couple of things that we've talked about in the past, but always good to bring up and kind of reiterate for people, especially right now as I think about the number of kids who are going back to school. And some of the thoughts that come into my head are how many seniors right now are about to go into their senior year of high school, and they're either currently 18, about to turn 18, and this was something that I had a misconception on that you had to clear up for me, and that's the need for that power of attorney.
Yeah, that's exactly right. And again, just kind of piggybacking on your point there, just some basic statistics, right? I don't think these are really too debatable that I'm going to say here. 3 facts about the average senior in high school, let's say at the end of their senior year. Okay, 1, most seniors in high school in Wisconsin, when they graduate high school, they are 18 years old. Okay, there's some exceptions. I'm an exception. I was 17 when I graduated high school, but I turned 18 the following July. So it's not like I skipped a grade or anything. I just had a later birthday, right? But most people, especially nowadays, the trend is to hold people back.
Right.
I feel like if I was born when my son was born, I probably would have been 18 going into my senior year and then turning 19 after I graduated. But that was just the trend back then. So Again, most seniors, the day they turn 18, most children in Wisconsin, the day they turn 18, they're still in high school. Number two, the average 18-year-old still lives at home with their parents or guardians. I mean, there are some emancipated adults, not very common. So most 18-year-olds still live with their parents or guardians. And three, most 18-year-olds, the day they turn 18, they are still on their parents' health insurance. Health insurance allows them to stay on until 26. Most 18-year-olds don't have their own independent health insurance. I mean, maybe if they're in the military or something along those lines, the day they turn 18. I mean, you got to be 18 to enlist anyway, so maybe shortly thereafter they do, but not the day they turn 18. And even that's a very small subsection there. So again, given that backdrop, they're seniors in high school, they live at home, they're on their parents' health insurance. Most people, with all due respect, like you mentioned, they would assume that if that child, after he or she turns 18, has a serious accident, gets in a car accident, ends up in a coma, that as the parents, of course we can make medical decisions. Of course we can talk to doctors and review medical records and find out about things like prognosis, care, things of that nature. You can't. The moment that child turns 18, regardless of their living circumstances, they are now protected by HIPAA. And again, HIPAA is something that most people, I think, are familiar with. It's the Health Insurance Portability and Accountability Act. It determines when and under what circumstances medical providers can share your information. Okay. Now, don't get me wrong. If that same car accident were to occur, and as opposed to the child being in a coma, he or she simply breaks their leg. I say simply because compared to becoming in a coma, that's a little better, I suppose. If they break their leg, sure, they're in a lot of pain, but they can say, hey, call dad, call mom, and that's fine. They can do that at that point. But if someone's in a coma, they can't articulate that desire. And that's when we can't assume, and hospitals won't assume legally, they cannot assume that that 18-year-old would want his or her parents to know. And as parents of soon-to-be 18-year-olds, right, give or take, our kids are around the same ballpark as far as age, that's a terrifying thought, that if we do have this event that occurs, which admittedly doesn't occur often, but as I always tell my clients, the likelihood of it occurring in any given circumstance is low, but it's not zero. It's somewhere north of zero. That's a terrifying proposition for a parent. Having a child in that compromise of a state and not being able to do anything for that child, and the remedy is very easy. Create a set of powers of attorney. I take the position in my practice that every single person over the age of 18 should have powers of attorney because, again, regardless of age, regardless of health, we're all one moment away from incapacity. And at that age, the most common issue there is a car accident. I mean, I hate to say it, but it is. The leading cause of death for an 18-year-old is car accidents. And it makes sense. You have inexperienced drivers. Nowadays, you have a lot more inattentive drivers with the texting and driving and all that stuff that didn't exist when we got our licenses, right? You know, and again, I have a 16-year-old who has a learner's permit right now, and, you know, he doesn't text and drive, obviously, in the car, but he's an inexperienced driver. He's getting better. We're proud of how his progress is going, but that's a moment as a parent, having a kid get behind the wheel. So, I mean, and he's a good kid. He knows how to operate things, but, you know, things happen. He gets in a car. He's not paying enough attention because we've had some close calls, even with me in the passenger seat, you know, or my wife in the passenger seat. And that's experience. That's like anything else. You only get better at doing something by doing something, right? So, but at the same time, that's a scary proposition. And you also mentioned what the idea of going off to college, because what ends up happening a lot of times is I will have some people who will call me up, existing clients of mine typically, to say, gee, you know, Junior's going off to college now. Now is the time to get those powers of attorney. And we can do that. But what I tell my clients is it shouldn't be the day Junior's going to college. It should be the day Junior turned 18. That's when we need him, because a lot of people think, oh, my goodness, well, if I'm local and it's, you know, he gets in that accident, we're fine. Again, not the case. It needs to be done the moment they turn 18. So, again, for those in the listening audience, perhaps you have children around the age of 18, or perhaps more importantly, or not, I should say more importantly, but perhaps more likely, you have grandchildren about to reach the age of 18, right? So, you know, let your children know, hey, I heard this on the radio. And again, ultimately, it's your decision. Like with everything else, all I'm doing is giving information. I'm explaining the pros and the cons. And who knows if it's going to happen. I'm not beating anybody over the head with a hammer to do this, but at the same time, we need to understand the consequences of not doing something. You know, the example I use in terms of consequences is speed limits, okay? Well, you know, everyone generally knows what a speed limit is, right? Any licensed driver has a general idea. And every driver is aware at some level not only that if you break the speed limit, you get pulled over, but an approximation as to what the consequences are, right? If you're going, between, let's say, I don't know, 5 to 15 over, you can expect a monetary fine. You're not going to jail, you're not losing your license, but you're going to have some sort of monetary fine. Well, that has to become information that's available. There are statutes that say what can be done. Now, compare and contrast that to you're going, 105 and a 55, right? The consequences are very different.
Right.
But you understand what they are. It's the same thing here. If you have a if you have a 18-year-old and you don't have these powers of attorney in place, you need to understand what the consequences are in the event that something happens. Now, the difference there is we can't control what happens to a random 18-year-old. We can, to some extent, control whether we speed or not, to a large extent, actually. I mean, sometimes if you're getting caught going down a hill or something, or, whatever the case is. I mean, I'm using, making some basic examples there, but I mean, it is, 99% within our control whether we speed or not, whereas it's 0% in our control whether something happens to that 18-year-old at a time where that child's going to college or even before college, driving to a job, driving over to a friend's house, those types of things.
Now, you did say, and I'm going to jump back to this, you said if you're over the age of 18, you should have a power of attorney. And that really comes in super handy, not just at that 18-year age, and not just at the, dad or grandpa's getting so old or grandma's getting so old that their capacity is not always there, so it's nice. But there's those in-between time frames where even as a 42-year-old adult, something could happen to me, and if I don't have the ability to convey my wishes,
right,
who's doing it for me then?
That's right. It's for anybody. It's just people only really think of it for the people who are getting older. They're starting to lose capacity to Alzheimer's or dementia. Gee, we want to have a document that gives us authority. And yes, that's important, but as you said, not to the exclusion of other groups. And what I would say about the group you just mentioned, the group I fall into, is married individuals. A lot of people incorrectly believe that if it's a spouse who's in that situation, the spouse will be able to make those decisions. I'll give you an example. I drive from here to my next appointment. I'm in a horrific car accident, taken to the hospital in a coma. But I don't have a healthcare power of attorney. My wife's in the exact same boat as the 18-year-old. Cannot receive any information regarding care, injuries, prognosis, things of that nature, nor can they make medical decisions. They can't even find out that I've been in that accident from a medical provider. Now, police officers, law enforcement, they're different.
Right.
They can certainly let you know, hey, you've been in the car accident, he's been taken to XYZ hospital. But once they get to XYZ hospital, that dissemination of that information without my consent, which again I can't give if I'm in a coma, violates my HIPAA rights. Now, some people say, well, that's ridiculous. Why wouldn't my spouse be able to know that? Well, what I would tell you is this. Let's just go off some facts here. A little over half, about 52% of marriages end in divorce. Okay, well, if I'm in a situation where I'm in in the process of a divorce, let's say, do I think I would want my wife to know about that? And do I want her making decisions? Probably not. Right? Maybe, or maybe it's the case that someone else in my family I'd rather do it. Maybe my sister's a doctor and I want her to be my power of attorney. I don't want that information shared with my spouse. So there's any number of things that may come up that cause the law to exist. And at the end of the day, the reasons don't matter. The law is the law.
Right.
And the law says, unless you have it in writing, not even a spouse can make those decisions. So, and again, like you said, I use 18 as kind of the arbitrary point because people are like, oh, that, because if it's under 18, it doesn't matter.
Right.
My two boys, 16 and 13, they both play football. Something happens to them, they lose capacity. My wife and I can absolutely make those decisions. Right. I mean, we can talk to whoever we want at that point in time. But the day they turn 18, we lose that ability. That's why on the most recent date here on February 6, 2028, Grady is signing powers of attorney. It will happen that day, right? Because we don't want to get caught in a situation where something happens that one day and we got a problem.
That makes sense. The number one question I'm going to hear people saying out there is, if I set up this power of attorney, am I locking something in? Can I change this later?
Oh, you can always change it because, again, the circumstances are different. Like, go back to the 18-year-old example. Most 18-year-olds in that situation where signing powers of attorney would probably want their parents making those decisions.
Makes sense.
Now, let's fast forward down the road. That 18-year-old develops a serious relationship. Maybe they're engaged or married. Certainly, they would want their significant other, I would assume, making those decisions at that point in time, right? And the documents can always be updated accordingly to reflect that. So, yes, it's just in a common phrase I use in estate planning, as morbid as this sounds, plan as though the incapacity or death is going to happen on the way home from the law office. Who would you want making those decisions at that moment in time? And then as circumstances warrant over time, we can certainly update them to reflect the changes in preferences.
Follow-up question to that: Are you? Because I guess I've never looked at a power of attorney document, which says a lot for how much I haven't done what you keep telling me I should do.
You bet.
But is that something where I could say, okay, for let's say my daughter who just turned 18 last July, so can I have me be a power of attorney, my wife be a power of attorney, and then have somebody else as like a third tertiary backup?
Yes, I do recommend that, and I would recommend you and your wife having joint authority, right? The idea of each with the ability to act independently if circumstances warrant. I mean, the example I give is this, and this is a very basic example, but I can remember getting a call from my wife when the boys were like 4 and 2, and one of the boys had fallen down a hill. It was weird and hurt himself, and my wife called me from the emergency room. I was like, it would be ridiculous for her to call me before, hey, should we take him to the emergency room? Yes, take him, go, do what you need to do, right? And the same thing applies there. Certainly if the nature of the injury is such that you have time, then absolutely, you and your wife would discuss and figure out a decision jointly. On the other hand, we may not be blessed with that ability to have that kind of time on our hands, so each of you has what they call it is co-agents, each with the ability to act independently. That's what I recommend there. Right. But to your point about the tertiary agent, I do recommend that because I would also think that, again, typically, not speaking specifically to your family, but typically there are going to be circumstances where the two of you, you and your wife and your daughter are in a car together, and then there's a car accident. So I say, well, maybe pick an aunt or an uncle, because I would venture to guess the number of times where you, your wife, and your 18-year-old daughter are in the car is a lot more than the times you, your wife, your daughter, and your brother are in the car. Right? It just doesn't happen as often. So that way, because again, if we just have you and your wife and all three of you are in a coma, that's a problem. We don't have anybody making those decisions. Right. So that's why I do recommend having that backup. Or if it's a situation where parents are divorced, again, typically that's okay, because if you have, ex-husband, ex-wife, it's unlikely ex-husband, ex-wife, and child are going to be in a car together. Right? It could happen. I guess it depends on the nature of the relationship and the nature of the feelings after the divorce. But at the same time, that's not as typical. So if it's a divorce situation, you could probably just stick with the two of them. But for a married couple, I mean, there's any number of times that my wife and I and the boys are in the car together, right? I mean, we just got back from a short trip to Ocean City, Maryland. So, I mean, these things happen. So having a backup agent there is always a good idea.
I can definitely agree with that. I want to move on to another thing that you work with, and this is one of those things where I want to touch on the distinctions first, and then dive into why people might choose one or the other. But obviously, when we talk about what you do in estate planning, there's this will-based planning and then trust-based planning. And me growing up, I always heard about like, oh, so-and-so's got a will, there's a will reading, there's this, there's that, whatever. And that was what I thought was like the ultimate, the end-all, be-all.
Right.
But that's not really the case.
It's not. And the question of will versus trust is the most common question I get asked in my practice because, again, the internet is a blessing and a curse, right? I mean, the internet is great for looking up random facts that are actually factual. What is the definition of this word? Well, you go online and it'll pop up Merriam-Webster and tell you what the definition of the word is. Great. Who is the actor who played this person in this movie? You put it up, that's factual.
There you go.
But when it comes to opinions, anybody can have an opinion, and how it's displayed on the internet based on SEO and things like that, we just don't know. Estate planning, at least in Wisconsin, in my experience, the differences between will-based planning and trust-based planning not only is the most frequent question that's asked, but it's arguably the most important question asked because it really does take us down two separate paths when that inevitable event does occur. And you're right, the prevailing wisdom is to create a will. That's everything that's been taught into you. I mean, the word trust, unfortunately, in my opinion, has been conflated with wealth.
Right.
People only think of trust for the wealthy. Now, first of all, just a normative statement, wealth is relative, right? There's a Chris Rock bit who talks about if if Bill Gates woke up with Oprah Winfrey's money, he'd be like, what happened to my account? It's the same kind of concept. Both of those people are exceedingly wealthy by our standards or anybody else's standards, but it's all relative, right? What I would say is this, is that one of the things I try to impress upon my clients is to not tie the word trust in with wealth. We tie the word trust in with guaranteed probate avoidance because that's really the main difference. Will-based plans can avoid probate, but trust-based plans are guaranteed to avoid probate. That's the biggest difference. Probate, a term almost everybody's heard before. Let me give a one-sentence working definition. What is probate? Probate is the process where a court oversees the administration of an estate. Estate goes to probate. We have a series of hearings, a series of filings, a series of deadlines, series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. Simply put, As an estate planning attorney, I encourage my clients to create plans that are guaranteed to avoid probate. Not likely, not possibly, guaranteed. Why? Why is probate avoidance so important? Boils down to three main reasons. First is cost. The average cost of probate in a state right now in the state of Wisconsin is between $8,000 to $12,000. The second is timing. The average length of probate in the state of Wisconsin is between 12 to 18 months. The third issue is publicity. When a will goes through probate, it becomes public record. Not only does the will become public record, but the amount, the character of the assets also become public record. So to summarize, negatives of probate: cost 8 to 12 grand, timing 12 to 18 months, public record. There are only two ways to avoid probate in Wisconsin. This is where we really get to the crux of the difference between a will and a trust. Way number one is this: we take a married couple, in this case the second spouse to pass away, or a non-married individual, whether that was someone who was always single, someone who was widowed, or someone who was divorced. We fast forward to the day they pass away. If at that time the value of the probate assets was less than $50,000, that is considered a small estate. Small estates avoid probate no matter what. Now, here's the thing. There's really no way around this one. The question I get most frequently is, I'll have people say, okay, well, I was told by my bank that this is not a probate asset. If I have POD beneficiaries, payable on death beneficiaries on the account, it's not a probate asset. Why do I need a trust? And my response to that is because we don't know if the POD is going to work. I'll give you an example. Let's just say, to make this easier, let's just say my wife and I were divorced, okay, and I had everything going to my two sons. So I go to my bank, I don't want to create a trust, or I got poor information or didn't get enough information, and I go to the bank and I say, okay, I want to avoid probate. I want to make sure Grady and Hudson, my two sons, are listed as 50-50 beneficiaries on this checking account. I list them as POD beneficiaries. I walk out of the bank. Will that avoid probate? The answer is maybe. And again, what I've learned in 19 years of practicing law, clients hate when the attorney uses the word maybe, right?
I was going to say, not the definitive answer I'm looking for.
But maybe is 100% the correct answer. And in 30 seconds, you and anyone else who's listening will have to agree with me on this. I have no idea, nor will I know until the day I pass away, whether either or both my sons survive me. Up until that day, it's an open question. If they do, if one or both do survive me, yeah, it avoids probate. But if they don't, it does not avoid probate. The trust, on the other hand, unlike any human being on this planet, has a 100% chance guarantee to survive you. There is no question that the trust will survive any one of us, and that's how we know that we will avoid probate with a trust. So again, I recommend trust-based planning for well over 90% of my clients to get that guarantee. Now, when would I not recommend trust-based planning? Really only in two instances. One would be if I have clients who really don't have much by way of assets. They have less than $50,000 worth of assets. They don't own. They're living paycheck to paycheck. Sure, will-based plan will be fine because we're never going to get above that $50,000 threshold anyway. The second time would be to use it as a stepping stone for a trust-based plan down the road. Common example would be you have a newly married couple, maybe they have a child on the way, and they just want to make sure we have guardianship provisions for the children. I will tell you this, we were talking about that before, guardianship. The only way under Wisconsin law to determine guardianship of a minor child is if it is in either a will or a trust. Nothing else works. I have so many people who will say, well, I have a notarized letter that says my sister gets the kids, or I have a recorded statement that my brother gets the kids. Worthless, completely unenforceable. It has to be in either a will or a trust. So when people hear that, young couples, they may say, okay, well, that's the most important thing I can do right now. We're growing our wealth. We're growing our equity in the home. If we even own a home at that point, let's do the will now and then create the trust down the road. And for my clients who do that, I offer what I call built-in credits. So the idea would be in time one, we want to create the will, which is less expensive than a trust. Whatever you pay for that will gets applied as a credit off the cost of a trust down the road. So that way you're not double paying for it. And again, I always tell my clients my rates won't stay the same. Nothing stays the same price-wise, except the Costco hot dog and Pepsi. That's a whole different issue, right? Beyond that, everything goes up. So the idea would be whatever you paid toward the legal services in time one gets applied as a credit off the services in time two. So other than that, I do recommend trust-based planning for pretty much every client I interact with because, again, we get the guarantee that we avoid probate when it's funded properly. Okay, I do have to throw that caveat in there because, you know, I ran into a case this morning where I had a client who had a trust drafted well over 20 years ago, and I asked, well, is it funded properly? And once I explained, like, no, that didn't happen at all. I'm like, well, that's great. The analogy I draw there to make people understand the importance of funding and something people can relate to is imagine going to a car dealership and buying a new car. Okay, you buy a new car. I'd say I've never seen this not be the case, but it always comes with a full tank of gas, right?
Right.
Full tank of gas. You drive around the new car. It's a great new car, and eventually one day the car stops working, and you can't figure it out. And you take it back to the dealership, and the dealership says, well, that's because you didn't put gas in the car. I mean, any sane driver, human being knows you got to put gas in the car, right? It's the same thing with estate planning. When you create the trust, that's like buying the car. The event of, or the act of funding the trust is like putting gasoline in it to make sure it continues to work.
Right.
So if any attorney, and I shouldn't say any attorney, but a lot of attorneys can create trust, but it's a matter of making sure that there's that connection between the trust and the assets, which is what I call funding, that oftentimes gets missed. And if that gets missed, it's not going to be worth doing because it's still going to have to go through probate. So again, that's something I help clients with as well, identifying what those assets are and explaining what is the best mechanism to make sure the trust receives those assets at death.
Now, the term I hear a lot is living trust. Does that just mean that even though you pass on, the trust is still around?
Yeah, but it's created during life is really the big thing, is that you're creating it during your lifetime, because the opposite of that is what's called a testamentary trust. So testamentary trusts are a lot less common now than they used to be, but what it would be is, let's just say right now, let's say I didn't do what I did for a living, I had no knowledge about this, and someone said, hey, Rob, create a will, okay? Well, one of the questions I'd ask the attorneys, I'm like, look, I got boys who are 16 and 13, I don't want them having the money at 16 and 13 if my wife and I die in a car accident on the way home from signing these documents. How do we avoid it? Well, you create what's called a testamentary trust. The testamentary trust only gets created upon the death of the second of Erica and I, my wife. And then the proceeds get in there, and then we could put in provisions for the trustee to oversee so that they don't have access to the money until they're 21 or 25, things like that. Now there are other ways to avoid doing that, so testamentary trusts are a lot less common, but a living trust just means it's created during the lifetime. It would be Erica and I creating a trust while we're alive, as opposed to one that merely gets created upon our death.
When it comes to trusts, one of the things that I kind of hear people say is, well, I don't want to lock anything in case something changes.
Right.
How do you address that?
Yeah, so the typical trust I recommend is what's called a revocable living trust. With a revocable living trust, the creator or the creators of the trust have full use, full access, full control over trust assets. Nothing changes as far as their day-to-day. They do whatever they want with whatever they have. And secondly, they have the ability to make any changes they want at any time. I referenced earlier in the show the 3 Ds and a B: death, divorce, disability, birth. There's any number of reasons why people may want to update trusts as time goes on. You know, some are positive, some are negative. An example of a positive one would be grandchildren, right? I mean, I don't have grandchildren yet, mercifully. But if I did down the road, maybe I'd want to adjust the trust to provide for my presently non-existent grandchildren. Right. That's a positive thing. A negative thing could be I could have a falling out with one of my sons and I don't want them to receive anything. That would obviously be a negative thing. We don't know what the future is going to hold, but again, because the trust is revocable, we can make those changes down the road. In fact, in most of the trusts I draft, when spouse 1 passes away, spouse 2 still has the ability to change things, because those life events could occur after spouse 1 passes but before spouse 2 passes. So the trust only becomes irrevocable, unchangeable, after both spouses die. Because you could imagine a situation where you have child 1, child 2, and it's 50-50, and child 1 says, well, you know, mom and dad really like me more. I did more for mom and dad. I'm going to change it to 75 me, 25% to my sibling. Obviously, that's a problem. So that's why the trust becomes unchangeable once the second parent passes away in this example.
And that trust essentially stays in existence until it becomes insolvent, like, and there's nothing left?
That's right. And, you know, people ask, well, when does that happen? And it depends, because the example I would give is this. I'll compare and contrast 2 situations. My parents have a trust. I have a sister, divided 50-50 between us. My parents both pass away. My sister and I survive. Should be pretty straightforward to distribute that, right? On the other, and it should be pretty quick. On the other hand, if my wife and I die tomorrow, we have boys who are 16 and 13, that trust might be around a long time, right? Because our trust has provisions saying the boys don't have full access till 30. You know, they have other assets, they have other things going on. So that trust could be open a very long time. We just don't know. It's a function. You use the term correctly, until the trust becomes insolvent. But the rate at which the trust depletes depends a lot on the circumstances of the beneficiaries once those principals, the creators of the trust, pass away.
And provisions can be put in there, obviously. I think about, like, for instance, pass away, what you want done with the house.
Yeah.
You know, it doesn't have to be as simple as so-and-so gets the house, where it could be, I want it specifically split. I want X amount of the proceeds to go to this charity, that charity, this kid, that grandkid, whatever.
Absolutely. Again, I would say that's less common. I would say
Right.
most people, when it comes to real estate, I'd say 95% of my clients treat it like any other asset. Just sold, split the proceeds, call it a day. 5% will have specific call outs for it. In other words, and that's typically more the case with secondary properties like family home, family cabins, things like that,
Right.
where you say we really want it to remain in the family, and this child hunts, this child doesn't, so we want the hunting land to go to the hunting child, things like that. But you can always customize. And then the question is, do we want to have an equalizing amount? Like, for example, if you want to leave the hunting land to child X and the hunting land is worth $200,000, do we want to give the first $200,000 of everything else to child Y, or do we just want to say, okay, child X gets the hunting land and then the rest is divided 50-50? Again, that's not my decision, but it's something as a lawyer I need to make sure my clients are aware of, because if you want to treat them equally, and as I learned very early in life and in law school, fair and equal are not the same. Okay,
Right.
People decide normatively what they want, and then they make the decision about whether they want it to be fair or equal. And that's something people need to be aware of, because it's like, oh goodness, if I'm allocating an asset worth $200,000 to this child, that's not going to be equal unless I equalize it. So that's up to the parents to decide.
Now, obviously, when you're having these discussions with your clients, there is a point of kind of required lawyerly candor when explaining, like, you can do it however you want to do it, but here's how the law is going to see
Right.
it. What are some misconceptions you have to kind of sway people away from?
Well, I think one is the will reading. I've been practicing law for 19 years. I've never once read a will like you would see in a movie. I mean, I would call beneficiaries. I would send notices to beneficiaries, but there's no will reading. That's one thing. I'd say the other one is the difference between a moral obligation and a legal obligation as it relates to specific personal property items, okay? A lot of people are of the belief that if they just create a list saying, I authorize this child to get this child to get that, or the more common one, the more amusing one, in my opinion, is putting stickers on the bottoms of things in the house, right?
We've all seen that.
You bet. That's a moral obligation. That's not legally binding. In order for it to be legally binding, it has to be in a legal document. So I do see that coming up too. And so, if clients understand that a moral obligation is there, wonderful. But if they do, in fact, want to make it legal, it's got to be part of the trust.
There you go. And obviously, the trust kind of, the good, better, best of everything. It sounds like the trust is the top way to go.
Absolutely. And it's one of those things where it's going to save significant dollars down the road. It's, again, we talked about $8,000 to $12,000 for the average cost of probate. A full trust, even with powers of attorney, is going to cost a fraction of that for an event, again, that we know is going to occur. And that's where a lot of people see the value proposition there. And again, at my firm, I don't charge for revisions. So if people for my trust-based plans, if people create a trust with me and they change things down the road, those changes are done on a complimentary basis.
There you go. I was actually going to ask you about that because I think that's an important thing to point out, because oftentimes when people think about working with a lawyer, it's I'm being charged by the minute for everything we do.
Right.
So it's nice that those revisions are covered. I want to talk again about how people can get a hold of you and how they can find you so that they can start the process, be it for that power of attorney, that intermediate will area, or getting into that full trust-based plan.
Yeah, best way to get a hold of me is by phone, 262-347-3444. Again, 262-347-3444. Complimentary initial consultation, 20% discount for WBEV listeners and DailyDodge.com viewers. Office locations in Beaver Dam, Saukville, West Bend, Germantown. Also make house calls or virtual visits, Zoom, phone, whatever works best for you.
There you go. Rob Melick, always a pleasure having you on, and hopefully the next time we're talking, the Brewers are continuing to knock it out of the park.
That's the plan.
Fingers crossed.
Absolutely.
This has been a paid program. The advice and opinions expressed on the program are solely that of Melick Law, not necessarily WBEV or Good Karma Brands.